Doing good. Today we have a very, very eminent speaker with us, Advocate Dr. Rachna Bharadwaj, who will be taking us through the topic of surrogacy in India, legal and ethical issues. Dr. Bharadwaj is an advocate registered with the original site of the Bombay High Court. Her field of work is IPR and medico-legal law. Currently, she's working as an independent legal and medico-legal advisor and consultant. Her area of work is diverse and includes work in the field of oncopathology, HIV/AIDS, medical negligence and healthcare laws, intellectual property rights, drug trial regulations, and cyber law and cyber forensics. She has lectured extensively on various legal and medico-legal issues at premier institutes in India. She has been on the panel of various conferences on issues related to legal and ethical issues in medicine and HIV/AIDS. She has written several articles in the Indian Business Law Journal on issues related to patents, patent linkages, clinical trial regulations, and medical negligence. She has been a visiting faculty of law at the University of Mumbai. She is an ex-professor of pathology and has worked at several hospitals in Mumbai, Pune, and Chennai in various capacities since 1989. She is a medical doctor who has turned an advocate and is registered with the original site of the Bombay High Court. She has worked in law firms and was an AVP medico-legal at Reliance Foundation Hospital. Her academic interests are in the area of Pali and Buddhist studies and philosophy. She is currently pursuing her MPhil in Pali and MA in philosophy at the University of Mumbai. Dr. Bharadwaj, it is truly an honor. I will leave the floor so that you could enlighten us on the topic. Thank you, everyone.
Okay, thank you very much for this lovely introduction. And let's get started with a very, very relevant topic, which is surrogacy in India, the legal and ethical issues. Now, I would be covering these topics. First, I will go through take you through the ethical issues. We'll discuss certain case laws which are relevant to surrogacy, and then, of course, the very important Surrogacy Regulation Bill of 2019. Now, India has emerged as a surrogacy hub for couples from different countries for the past few years. And of course, there have been instances of unethical practices, exploitation of surrogate mothers, abandonment of children born out of surrogacy, and import of human embryos and gametes. Now, this has, of course, happened because so far we did not have a regulation for any legislation to regulate surrogacy practices. Now, the new law that has come is to prohibit potential exploitation of surrogate mothers and to protect the rights of children born through surrogacy. Of course, this is a Latin term. It comes from a Latin term, surrogatus, which means a woman who acts as a substitute for another woman. It is a third-party reproductive practice or an arrangement where the intending parents and the surrogate mother mutually agree that the surrogate shall later become pregnant, gestate, and give birth to a child, and shall legally and physically transfer the child to the intending parents without retaining any parentage or parental obligations. Now, of course, there are two types of surrogacy. We have the traditional surrogacy and gestational. Traditional surrogate is a woman who gets artificially inseminated with the father's sperms, and then carries the baby and delivers it for your partner and raise for the parents to raise. Now, a traditional surrogate is a baby's biological mother. That's because it was her egg and fertilized by the father's sperms. So, of course, in our case, we are not going to be talking of traditional surrogacy because it is gestational surrogacy which has been given the legal sanction. Now, gestational surrogacy, the surrogate mother is not genetically related to the child. Further, there are these gestational surrogacies of two types, which is altruistic, which is based upon care, concern, and the same there is no scope for any monetary compensation. Now, commercial surrogacy, again, where the surrogate mother is paid over and above the necessary medical expenses. But we will be seeing in the bill that it's only the altruistic surrogacy that has been permitted as per the new Surrogacy Regulation Bill of 2019. Now, surrogacy per se and the Surrogacy Regulation Bill 2019 is a unique amalgamation of social, ethical, moral, legal, and scientific issues. Now, it is very important to harmonize these conflicting interests to ensure the betterment of child while protecting the rights of the surrogate mother. Now, there were several vexatious issues that were discussed all over the world, and some of the very, very prominent cases which helped in sort of making Surrogacy Regulation Act was the Baby M case in the United States, the JCB versus the Superior Court, the Baby MANJI Yamada case, which we would be discussing in the case laws. And of course, all these laws are to ensure the betterment of the child while protecting the rights of the surrogate mothers. Now, in baby JC's case, of course, there was the custody of the child was sought by 5 parents: the genetic mother, the commissioning mother, the surrogate mother, the commissioning father, and the genetic father. So clearly, I mean, there was a contentious issue, and we had to come to a sort of middle ground. Now, while commercial and altruistic surrogacy is legalized at some places, of course, in India, it's only the altruistic surrogacy. In some of the places, there's a blanket ban on surrogacy completely. Now, obviously, I mean, the people who say that there should be a complete ban on surrogacy, they say that the human dignity is compromised and it's very, very exploitative. So they do not allow surrogacy, and surrogacy in all forms is banned. Now, this is in countries like France, Finland, Italy, Japan, Spain, Sweden, Switzerland, Hungary, Ireland, and all other places. And commercial surrogacy, of course, is allowed in the United States and the Russian Federation, Colombia, Ukraine. And also in India, because it was unregulated, it was a practice, but it was not regulated. Now, of course, the challenges among these is to find a middle way, as I discussed. And now, obviously, there is conflicting ideas where we have to protect the dignity of the woman as well as give an option to the infertile couple who are not able to conceive on their own. Now, of course, surrogacy is an arrangement where a woman, the surrogate, offers to carry a baby through pregnancy on behalf of a couple and then return the baby to the intended parents once it is born. Now, in surrogacy, an embryo is created using an egg and a sperm produced by the intended couple and is transferred into the surrogate's uterus. The surrogate has no genetic link to the child. Her eggs cannot be used to conceive the child. So this, we have seen that in traditional surrogacy, this is allowed. But in gestational surrogacy, which is the surrogacy which is allowed as per the Indian bill that will eventually see the light of the day. Now, the Surrogacy Regulation Bill of 2019, of course, is a step which seeks to regulate surrogacy procedures in such a way as to stop exploitation of poor, vulnerable women. Because we saw in the past that there were a lot of poor women who opted for surrogacy, and not just once, but several times, compromising with their health. So this is, of course, a bill which says that surrogacy can only happen, only once in a lifetime a woman can become a surrogate, not more than that. So that really protects the health of the surrogate. Now, this is, of course, to ensure the protection of rights of the child born out of surrogacy and to facilitate only needy, infertile couple and widow and divorced women to have a child to complete their family. And, of course, to prohibit commercial surrogacy and allow only altruistic surrogacy to happen. Now, India clearly has emerged as a surrogacy hub for couples from different countries for the past few years. And we have seen a lot of media reports which condemned, commercial surrogacy in India. The Law Commission of India, in its 228th report, recommended for prohibition of commercial surrogacy by enacting a suitable legislation. Now, because there was a lack of legislation to regulate the surrogacy practices, these were misused by the surrogacy clinics, and commercial surrogacy and unethical practices were very, very rampant in these areas. Now, because of this, it was felt that a legislation be enacted. Now, some of the very, very key features of the Surrogacy Bill 2019 is the constitution of the Surrogacy Board at the national and the state level to allow ethical, altruistic surrogacy to the intending infertile Indian married couple between the ages of 23 to 50 years, and in cases of a female, and 26 to 55 years in cases of a male. Now, the intending couple should be legally married for at least 5 years and should be Indian citizens. So it does not allow any import of any genetic material or any, surrogacy provisions from outside. So it's only intended for the Indian citizens. Now, the intending couple shall not abandon the child born out of surrogacy procedure under any condition. So there were a lot of instances, once the child was born, and if the child had any congenital deformity, the children would be abandoned. Now, the current provisions in the bill do not allow that, and they say that the same rights and privileges are available to the biological child. Now, the surrogate mother should be a close relative of the intending couple and should be an ever married woman having a child of her own and between the ages of 25 and 35 years. Now, to provide that, the surrogate mother shall be allowed to act as a surrogate mother only once. Also, the provisions to constitute the surrogacy board at the national level and to constitute the surrogacy boards at the state and the union territory level as well. Also, there are provisions to appoint one or more appropriate authorities at the center and the states and the union territories. And of course, there are provisions where the surrogacy clinics will have to be registered. Now, the offences, of course, it's a punishable offence, and imprisonment for a term which shall not be less than 10 years, and with a fine which may extend to about 10 lakh rupees. This was important to, regulate the activities of the surrogacy establishments. Now, it is only permitted for intending couple with proven infertility. They should be Indian citizens, married for at least 5 years, and without a child, whether biological, adopted, or surrogate. The woman should be 25 to 50 years old, and the man should be 25 to 55 years old. Now, it's very important to, as I mentioned also in the Art Technology Regulation Bill, that the inclusion criteria are very, very stringent, and one needs to really take into consideration those, because now this will be certified by the appropriate authority, which we'll see once we come to the bill, what are the requirements for a couple to actually go in for surrogacy. So there has to be proven infertility through diagnosed medical conditions should indeed be the only criteria to permit surrogacy. Now, there are several challenges in surrogacy. The appropriate authority will issue certain certificate which will be very essential, and this will be the eligibility certificate to the intending couple. And the surrogate mother should be a close relative. The focus, of course, is to have a genetic child and have a traditional family. So that is why, there is more and more dialogue as far as, the gestational surrogacy, and only with the gametes of the, intending couple. And generally, the surrogate used to be any woman who could, was vulnerable and who could be paid and become a surrogate. And now this case, the provision is to have a close relative who becomes a surrogate. Of course, there are complications to that as well, because whether this kind of an arrangement is possible in close families. Now, of course, the bill, once it becomes a law, the same-sex couples, single parents, live-in couples will not be allowed to opt for surrogacy as they currently can. So, in the very famous, Bollywood, there are instances where children have, been born through surrogacy, and but now, the same-sex couples and single parents cannot opt for surrogacy procedures. Of course, it prevents single parents, same sex couples, divorce or widow couples, transgender persons, live in partners, and foreign nationals from using a surrogate mother in India. The bill, of course, prohibits commercial surrogacy and allows only altruistic surrogacy. Now, of course, some people feel that this takes away the livelihood of women who would actually earn by offering themselves for surrogacy. But of course, these are the points that can be really debated, and these come in the domain of legal, ethical issues. While, of course, there's no precise data how India has emerged as a global hub for commercial surrogacy, but it is about $2.3 billion industry and employs thousands in more than 3,000 clinics nationwide. Of course, now the provision is to actually get these clinics registered, so there have to be minimum requirements that have to be met before these clinics actually get registration. So when there was no regulation, single people, those in live-in relationship, of course, we mentioned, could take the benefits of surrogacy. Now, considering the Supreme Court jurisdiction on live-in relationships, children of live-in couples are considered legitimate. Now, by denying surrogacy to these groups of individuals like single parents and homosexual transgenders, you're actually denying them rights, making it regressive or limited view of what a family is. So truly, I mean, if this is not integrated, there are still going to be concerns, because the Supreme Court has sort of given a legal status to live-in relationships, to transgenders and the third gender. So these will be issues actually which will be very challenging once the act really comes in. Of course, there are some other issues which are very important when there are babies born out of surrogacy. So arrangements for breastfeeding is a concern. Since the surrogate mother would be a close relative, this provision would facilitate breastfeeding. And the Infant Milk Substitute Feeding Bottles and Infant Food Regulation of Production, Supply and Distribution Act of 1992 provides for regulation of production, supply and distribution of infant milk substitutes, feeding bottles and infant foods with a view to the protection and promotion of breastfeeding and ensuring the proper use of infant foods, which will be allowed. So, of course, these provisions will be as part of the rules which will later be formulated. So far, we don't have clarity on the rules. It's only the bill that we are actually looking in. Now, just to discuss some of the surrogacy case laws which confronted the courts, we will go through the very famous Baby M case, where a Baby M, of course, this is a pseudonym which is used in such conditions. This was a very, very landmark case in the United States. And it was the first ruling on the validity of surrogacy. Now here, I mean, there was Mary Beth Whitehead. She would be inseminated with William Stern's sperm, making her a traditional as opposed to gestational surrogate, bring the pregnancy to term, and relinquish her parental rights in favor of William's wife, Elizabeth. After the child was born, Mary Beth decided to keep the child. And she even sort of threatened that she would commit suicide if the custody was not given to her. But later, she sort of kidnapped the child, and William and Elizabeth Stern sued Mary Beth and said that they are the parent, they're the legal parents, and they ought to have the custody of the child. Now, the New Jersey court ruled that surrogacy contract was valid according to public policy and recognized that Mary Beth Whitehead was the legal mother of the child. And of course, it asked the family court to determine whether Whitehead as a mother or Stern as a father should have legal custody to the infant using the conventional best interest of the child analysis. So, generally it is the best interest of the child which is taken into consideration, and this is what the court actually asked them to do. Now, Stern was awarded custody with Whitehead having visitation right. So this was a very, very, it got a lot of media attention and was a very, very famous case. Later, there was a documentary made on this particular movie. Now, of course, the baby was called Sarah before, then she was called Melissa. Later, her name was changed to Melissa Elizabeth Stern. Now, according to the initial decision overruled, Whitehead would be considered a traditional surrogate as opposed to gestational surrogate because she was the genetic mother of the child. The Sterns feared because Elizabeth had multiple sclerosis and she was vulnerable. So they thought their child would be vulnerable. So they actually went for surrogacy procedures. Now, on March 27, 1986, Whitehead gave birth to a daughter. She managed initially to get a birth certificate naming the infant Sarah Elizabeth Whitehead and handed the baby to the Sterns. Of course, this got a little more complicated later, but later, of course, the legal rights as a parent were given to the Sterns, and Whitehead was given, as we mentioned, was given to the visitation rights were given to Mary. Now, this case attracted much attention as it demonstrated that the possibility of third-party reproduction raises a novel legal and social question about the meaning of parenthood and the possibility of contracting around issues of pregnancy and childbirth. And of course, this was also used as a precedence in AGR and DRH case of where the intending parents were homosexual male couples. They created an embryo using an anonymous donor ovum and the sperm of one of the husbands. The sister of the other husband carried the embryo to term and originally delivered the child to her brother and his husband. But a year later, asserted her own parental rights, even though she was not genetically related to the child. Now, this particular precedence was used, and the court ruled that full custody be given to the biological father. So this was a very, very relevant. Baby M's case was a very, very important case as far as surrogacy was concerned. Okay, as an aftermath, very interestingly, in March 2004, when Melissa became an adult, she terminated Mary Beth's parental rights and formalized Elizabeth's maternity through adoption proceedings. Very interesting to know this. And the biological mother, Miss Whitehead, wrote a book about her experience in 1989. And so, yeah, this is a very, very interesting case. Now, there was another case, baby MANJI case, where a child was born to an Indian surrogate. Her commissioning parents were a couple from Japan who filed for divorce shortly before the child was born. Now, neither the intended mother nor the surrogate mother wanted to take custody of baby MANJI. She was, of course, a baby girl. Now, the baby was eventually permitted to leave for Japan after Japanese government issued a one-year visa to her on the humanitarian grounds. The father wanted to take the custody of the child, but the Indian law did not permit single men to adopt a female child. So that was the big issue. But when she was given the option to go to Japan, her mother had to accompany her. Of course, since that time, the issues around surrogacy have only intensified. Now, in the controversy that followed, several infirmities in the arrangement came to light, including absence of a legal contract between the parties, a fact that many saw as a worrying reminder of the potential for exploitation of native surrogates. Now, MANJI was born to an Indian surrogate mother in Gujarat, and she was to be adopted by her Japanese parents, as I mentioned. And but the couple, did not want to. I mean, the mother did not. They divorced, and the mother did not want to take the custody of the child. And since the Indian law doesn't allow, we have discussed about this. The other case, which was very important, which came in the Gujarat High Court, this was again a landmark judgment. Here the court held that the surrogate mother as a natural mother and her nationality has to be considered alone to decide the citizenship of newborn babies, irrespective of the nationality of the father. Of course, the new bill that has come up has sort of integrated these uh, infirmities, these kind of lacuna in the bill. So it provides for all these, it has taken care of all these provisions. So that's again a very good thing to know. Now, this was this baby Jalan's case, Jan Balaz's case was that the German national had sought Indian passports for his twins Balaz Nicholas and Balaz Leonard. The twins were born to an Indian surrogate mother, Martha Christie in Anand, with the help of surrogacy expert Dr. Naina Patel. Balaz and his wife sought Patel's help as a surrogate. An Indian woman donated eggs, which was fertilized with Balaz's sperm and deposited in Martha's womb. On January 4th, Martha gave birth to the twins. Now, obviously, the passport, when the names were written, these had the names of the mother, and the authorities said that Suzanne, who did not conceive the child, was mentioned as their mother in the birth certificate. So this was, of course, violation of Birth and Death Registration Act of 1969. And Balaz submitted the passports, but then moved the High Court, saying he had to take his sons to Germany and apply for citizenships. So the court said a lot of legal, moral, and ethical issues arise in this case, which have no precedent in this country. We are primarily concerned with the rights of the innocent babies, much more than the rights of their biological parents, surrogate mother, or the donor of the ova. Now, emotional and legal relationship of the babies with the surrogate mother and the donor of the ova is also of great relevance, but a comprehensive legislation dealing with all these issues is very, very imminent to meet the present situation, which have no clear answers in the existing system in this country, the court said. But as we will discuss, and we'll see that the new bill has taken cognizance of these factors. Now, on the boy's citizenship, the court said, we in the present legal framework have no other option but to hold that the babies born in India to the gestational surrogate are citizens of this country and therefore entitled to get the passport. The court then asked the passport authority to release the boy's passport. Now, we will be discussing the Surrogacy Regulation Bill of 2019, which has 8 chapters, but I would be only taking the relevant portions of the Surrogacy Bill. Just very, very important definitions that are very important for us to know. What is altruistic surrogacy? It means the surrogacy in which no charges, expenses, fees, remuneration, or monetary incentive or whatever nature, except the medical expenses incurred on surrogate mother and the insurance coverage for the surrogate mother are given to the surrogate or her dependents or her representative. Of course, it's important to also know what is meant by abandoned child. Now, this means a child born out of surrogacy procedure who has been deserted by his intending parents or guardians and declared as abandoned by the appropriate authorities after due inquiry. To know what is commercial surrogacy, which is not permitted, means that commercialization of surrogacy services or procedures or its component services or component procedures, including selling or buying of human embryo or trading in the sale or purchase of human embryo or gametes, or selling or buying or trading the services of surrogate motherhood by way of giving payment, reward, benefit, fees, remuneration, or monetary incentives in cash or kind to the surrogate mother or her dependents or her representatives, except, of course, the medical expenses incurred on the surrogate and the insurance coverage for the surrogate mother. This we needn't take. Insurance, of course, means an arrangement by which a company, individual, or intending couple undertake to provide a guarantee of compensation for specified loss, damage, illness, or death of the surrogate mother during the process of surrogacy. Intending couple means a couple who have been medically certified to be infertile couple and who intend to become parents through surrogacy. And we will see that getting this certificate by the appropriate authority is mandatory as per the provisions of this bill. Surrogacy means a practice whereby one woman bears and gives birth to a child for an intending couple with the intention to hand over the child to the intending couple after birth. Surrogacy clinic, of course, we need to know this because now, each surrogacy clinic will have to be registered. And it's only then that it becomes a surrogacy clinic. So far, this registration was not required, so there was no need to do that. But we will see what is a surrogacy clinic. It's a center or laboratory conducting assisted reproductive technology services, in vitro fertilization services, genetic counseling center, genetic laboratory, art banks conducting surrogacy procedure, or any establishment by the name of the surrogacy clinic. And this has to be done very, very as per the provisions of this law. Also, the surrogacy procedure means all gynecological, obstetrical, or medical procedures, techniques, tests, practices, or services involving handling of human gametes and human embryo and surrogacy. Now, of course, this has also to be read with the Art Technology Regulation Bill of 2020. There are, if you are to use the services of the clinics or the banks, then you will have to go to a registered bank or the registered art clinic to avail to the gametes. So it's very, very important to do that. So that has to be read along with the surrogacy bill as well. Who, according to this act, is a surrogate mother? It is a woman bearing a child who's genetically related to the intending couple through surrogacy from the implantation of embryo in her womb and fulfills the conditions as are provided in subclause B of section 3 of subclause B of clause 3 of subsection 4, which makes it mandatory that it is the surrogate mother's gametes cannot be used as per this particular act. Of course, for us, it's very important to know that these surrogacy clinics will have to be registered. So no surrogacy clinic, pediatrician, gynecologist, embryologist, or the registered medical practitioner or any person shall conduct, offer, undertake, promote, or associate with or avail to commercial surrogacy in any form. Now, no surrogacy clinic shall employ or cause to be employed or take services of any person, whether on honorary basis or on payment, who does not possess such qualification as may be prescribed. So these provisions are very, very stringent. And of course, no registered medical practitioner, gynecologist, pediatrician, or embryologist, or any other person shall conduct or cause to be conducted or aid in conducting by himself or through any person surrogacy or surrogacy procedure at a place other than the place which is registered. Now, this is again very important to know. Once your clinic is registered, the geographical location of that premises is what is registered. So if you shift your clinic to the other, you will have to inform the authorities over the change, and they will sort of issue you fresh licenses of practice. Now, these are some of the important issues because, we do not sometimes take this into consideration. So even if you change the floor in the building that you're conducting the procedure, that is not the facility which is registered. So if you shift, you have to get a fresh inform the authorities of this change on the premises. So this is very, very important to know because also because in the PCPNDT Act, it has been seen that, these the machines which are used for the purpose of, gynec ultrasound, these machines are taken from one room to the other when that is not the procedure that is really available. So it's very important to understand that you can only perform these procedures in the facility that is registered under this particular act. Of course, any form of canvassing or advertisement is not permitted. Also, it is, also to protect the surrogate mother from being exploited. So this provision is again very, very important for that. Okay, so it is also aimed at promoting a surrogacy clinic for commercial surrogacy or promoting commercial surrogacy in general. It also aims at seeking a woman to act as a surrogate mother, state or implies that a woman is willing to become a surrogate mother, or advertises commercial surrogacy in print or electronic media. So any form of digital advertisement is not really permitted. Of course, no surrogacy clinic shall store a human embryo or gamete for the purpose of surrogacy. As I said, you have separately the art clinics and art banks, which will now be storing these embryos for the purpose of implantation. So surrogacy clinics will not be providing these facilities. And sex selection, of course, it is also not permitted by the PCP-NDT Act, and also the same applies to the Surrogacy Regulation Bill as well. Okay, so also it's important to regulate surrogacy and surrogacy procedures. Okay, so no place, including a surrogacy clinic, shall be used or be caused to use by any person for conducting surrogacy or procedures except for the purpose which are specified in the Act. And no surrogacy or surrogacy procedure shall be conducted, undertaken, except for the purpose when either or both members of the couple is suffering from proven infertility, when it is only for altruistic surrogacy purposes, when it is not for commercial purposes, or for commercialization of surrogacy or surrogacy procedures. Of course, the rules will also come forth where there are certain genetic disorders in which the woman may not be able to, conceive herself, or would want to not, bear the child. So in that case, surrogacy may be applied, but these diseases would be mentioned in the rules and regulation that will be provided later. Any other condition or disease, as I mentioned, no surrogacy or surrogacy procedure will be conducted except the intending couple is in possession of a certificate. So it's very, very important that the intending couple gets the certificate from the appropriate authority, and which proves that she is infertile, or the couple is infertile, and the intending couple, and this will be by the district medical board. So once they certify this, it's only those couples who can actually opt for surrogacy procedures. So that makes it very, very regulated in a way. Of course, an insurance coverage again has been given in this case for an amount which may be prescribed in favor of the surrogate mother for a period of 16 months, covering the postpartum delivery complications from an insurance company or an agent which is recognized by the IRDA authorities. Of course, the surrogate mother should have an eligibility certificate by the appropriate authority on the fulfillment of the conditions. Now, what are these conditions? Now, no woman other than an ever married woman having a child of her own and between the ages of 25 to 35 on the day of implantation shall be a surrogate mother or help in surrogacy by donating her egg or oocyte or otherwise. So clearly the age has been defined, and she cannot have her oocytes for the purposes of surrogacy. No person other than a close relative of the intending couple shall act as a surrogate mother and be permitted to undergo surrogacy procedures as per the provisions of this Act. So this has become very, very stringent, and it is good that the intending couple, as well as the surrogate mother, have to have an eligibility certificate which will be given by the appropriate authority. So there are a lot of checks and balances in this particular bill that we see, and which is a good news, because this is clearly going to prevent any kind of malpractices. Yes, we have seen a certificate of medical and psychological fitness for surrogacy and surrogacy procedures will be given from a registered medical practitioner. Because we have seen in the case laws that, after the child is born, the mother who is bearing the child gets obviously very, very attached emotionally to the child, and she might not uh, want to give the child. So in this case, I mean, it is, you have to see whether she's fit enough to sort of do that. And that is why, I mean, a complete checkup has to be. A psychological fitness is very, very important when the mother becomes a surrogate. Okay, an eligibility certificate for the intending couple is issued separately by the appropriate authority on, of course, the fulfillment of these conditions. The age of the intending couple is between the age of 23 to 50 years in case of female, and a male between the ages of 26 and 55 years on the day of certification. Also, I mean, the intending couple should be at least married for 5 years, and they have to be Indian citizens. The other requirement is that the intending couple do not have a surviving child biologically or through adoption or through surrogacy. Of course, there are certain exceptions where the child is mentally or physically challenged or suffers from a life threatening disorder or fatal illness with no permanent cure, and approved, of course, by the appropriate authority with due medical certificate from a district medical board. And of course, these conditions and exceptions will be enlisted in a detailed fashion in the rules and regulations that would follow the bill once it becomes an act. Of course, it's very important for the doctors to explain the outcomes of surrogacy, and important that they explain the side effects and after effects of surrogacy. And this has to be, of course, a written consent needs to be taken of the surrogate mother, and it's very, very important that it's in a language that she understands. Also, I mean, she waives off her right to claim any parenthood to the child. So these have to be inherently, integrated in the contract or the consent form. Okay, another fact is that the surrogate mother shall have no option to withdraw her consent for surrogacy before the implantation of the embryo in her womb. So she can opt out of surrogacy before the embryo is implanted. So it's clearly safeguarding the interest of the intended couple. Now, as we have seen in our discussion, that once the surrogate child has all the legal rights of a biological child, so even if there are deformities or birth defects, the intending couple cannot abandon the child. They have to accept the child after the child is born and give him the same rights that are given to the biological child. And of course, the number of oocytes or embryos to be implanted in the surrogate mother for the purpose of surrogacy shall be as may be prescribed by the rules. Okay, so also, I mean, what do you do in cases of medical termination of pregnancies? Now, these rules and regulations again will be prescribed within the rules and regulations that will come once this bill becomes an act. So we will have the indications of doing a medical termination of pregnancy. Registration, of course, the surrogacy clinics have to be duly registered under this act. And of course, there's a procedure. It has to be given. A particular form has got to be filled. Particular fees has to be paid, and then I mean the appropriate authorities will actually come to your premises and see whether there is infrastructure, whether there is equipment, and whether specialized manpower is available in the facility, and there are enough diagnostic facilities available. Only then, once they're assured, the clinic can be registered as a registered surrogacy clinic. Okay, so the certificate, of course, has to be placed in a very prominent and conspicuous place, just like your, if you're, if there is an ultrasound procedure or any of these procedures, the registration has to be put right at a place where it is conspicuous. So it's important that the certificate of registration be displayed. In cases, I mean, where there is the appropriate authority feels that the some of the rules and regulations have been flouted, it has the authority to cancel the registration, and they also have suo moto authority to cancel the registration. Okay, yeah, this is, of course, the surrogacy clinic may, within a period of 30 days of cancellation, approach the state government or the central government and appeal as to why their registration should not be cancelled. So, appeal lies within 30 days of cancellation or suspension of registration. As I mentioned, National and State Surrogacy Board will not go much into that. Now, it's important to know what are the functions of the appropriate authority. It grants, suspends, or cancels registration of a surrogacy clinic, to enforce the standard to be fulfilled by the surrogacy clinic, to investigate complaints of breach of the provisions of this Act, rules and regulations which are made under this Act, to take appropriate legal actions against the surrogacy clinics, either suo moto, or if it's brought, or if it is a complaint, which has been filed by the state board. Of course, to supervise the implementation of the provisions of this Act. Now, the appropriate authority has a wide-ranging powers. It can summon any person who's in possession of any information relating to violation of the provisions of this Act. Production of documents, of course, they can anytime ask you whatever documents they need. They can search your premises, and of course, there are any other powers as may be prescribed. But the appropriate authority shall maintain the details of registration of surrogacy clinics, cancellation of registration, renewal of registration, grant of certificates to the intending couple and surrogate mothers, or any matter pertaining to the license, grant of license, or of the surrogacy clinic in any format as may be prescribed. Now, it's important to know that these, have certain penalties if there is any breach that the clinics conduct. So, it's important to know that no person, organization, surrogacy clinic, laboratory, or clinical establishment of any kind shall undertake to provide commercial surrogacy or its related component procedures or services in any form, or run a racket or an organized group to empanel or select surrogate mothers, or use individual brokers or intermediaries to arrange for surrogate mothers and for surrogacy procedures at the clinics, laboratories, or any other place. So, and also they shall be punished if there is any commercial surrogacy which is being practiced in the clinics. Now, also, I mean, there are provisions for in cases of abandonment of the child, or there is exploitation of the surrogate mother. Again, there are provisions under this Act which will be as per the procedures. So, of course, these provisions, we clearly see that it has taken care of the child, the intending couple, and the surrogate mother. So everybody agrees to a certain set of conditions before getting into the procedure. It is very clear to the doctor what they are looking at, because sometimes it could be very problematic if these provisions are not known, and we sort of, not that we want to flout these regulations, but if we are not aware, we don't see it coming. So it's very, very crystal clear that what are the provisions under the law and how we need to sort of go about establishing the clinics, the surrogacy clinics. Of course, the punishment is imprisonment for a term which may extend to 10 years with a fine which may extend to 10 lakh rupees. So clearly, we see that the punishment, of course, is a penal provision, but if we know the law, we don't really reach that stage. So it's good to know. It's good to know the law actually before it becomes an act. Now, for the purposes of this section, of course, advertisement includes any notice, circular, label, wrapper, or any other document, including advertisement through internet or any other media in electronic or print form, and also includes any visible representation made by means of any hoarding, wall painting, signals, light, sound, smoke, or gas. So this is important to know. Sometimes we feel we are not advertising, but if we know that no advertisement whatsoever need to be done, we obviate any punishments that would follow. We have seen this, and okay, this is done. Okay, so whoever contravenes the provisions of this act, there shall be punishable with imprisonment for a term which may extend to 3 years, and with a fine which may extend to about 5 lakh rupees. And if there are continued violation, contravention, which continue, then 10,000 rupees for every day during which such contravention continues after conviction for the first such contravention. And of course, this can also lead to cancellation and suspension of the licenses of the surrogacy clinic. We need to know that these are cognizable offenses and non-bailable and also non-compoundable. So, in order that we don't sort of be caught unawares, it's good to know the provisions of the surrogacy regulation bill. So here I would end my presentation, and I would be happy to take any questions that you might have. Okay, so there are some interesting questions which have sort of come up, and so one of the questions is, what are the ethics involved in the process of choosing a surrogate? As I've mentioned, that choosing a surrogate actually is that they should be related and within the family. So there are no provisions for having a surrogate apart from the family, close family. So those are clearly very clearly mentioned in the law. What is the expected involvement of the intended parents and surrogates throughout and after pregnancy? Yeah, that's a very pertinent question. And there can be normal interactions. And of course, the provisions are very, very clearly mentioned in the contract. So definitely, I mean, if the child, if the pregnant, if the surrogate mother, because it's a close family member, the intending couple has, access to the mother, so they can meet her from a regular time to time basis, inquire about her health, nutrition, and other things. And of course, the provisions of insurance are already mentioned in the law, so it's important in those matters. Okay, so what are all the medical legal aspects need to be considered for a surrogacy match, which I have already mentioned. How long does the medical legal process take? Well, it's a long drawn procedure, so it really depends on the sensibility of the courts. So it's not something that you can tell them that, okay, this is the time frame. with the medical legal, once there's a contentious issue, then the matter is in the court, and it can take many, many years. The ethical legal contracts, once we are before the surrogacy procedures are initiated, there are contracts which are in place. So there's no question of flouting those contracts, because it's already inherently mentioned in the consent form or the contract. So, uh, okay, so I have uh, should surrogacy be altruistic or not? Clearly, I mean, we have discussed that surrogacy should be altruistic, because so far, when there was no regulation, there was a lot of commercial transactions which were involved, and a woman was only multiple times she would become a surrogate. So that really compromised with the health of the mother. So it's very important to have altruistic surrogacy and not commercial surrogacy. Okay, so that any further questions if you have, you can ask, or we are good to end. Okay. Okay.
Thank you so much, Dr. Bhardwaj, for your take on surrogacy in India, legal and ethical issue. It was such an informative webinar, and I'm sure our physicians community have learned a lot from this much needed medical legal session.
Sure. It was a pleasure, and thank you very much, and good night, everybody.
Thank you once again for taking our time. Thank you.